Hello everyone. When you're looking to study abroad, you ask us questions on program choice, university selection, ROI, destination country, and visa process. What you forget to do your research on is if plan A and plan B don't work out, do you have any legal options? Welcome to this round of EdTalks where we go all out to explain today's most trending topic, the Judicial Review, JR for short. The Canadian judicial review process is a legal procedure in the federal court to challenge a government decision, like one from IRCC, for being unreasonable or procedurally unfair. You file an application for leave and JR along with legal documents and seek the court's permission to proceed. Now, if leave is granted, a judge will review the case to determine if the original decision by the visa officer in this case was made correctly and may uphold the decision or send it back for reconsideration. A reconsideration could finally result in a visa success at the end of the process. Seems complex? No, it isn't. And to simplify it for you, we have with us Karunvir Samra, a legal counsel who himself was an international student and is now an immigration lawyer in Canada. Hi Karunvir, welcome to the famous Canam EdTalks show. My first question to you is, why should a student need to know about judicial review while just looking to study in Canada? Is it like an insurance policy that one should be armed with for current times?
I will give you a high overview of what judicial review is. And in very simple terms, judicial review is basically challenging any decision that the government makes. So, where it is relevant to study permit applications is you're submitting an application to the government and somebody there, an immigration officer, is going to make a decision. And now that decision they make, if you think that decision is unreasonable for whatever reasons they give, you don't have enough finances, they don't believe in, the purpose of your trip. They don't think you're going to be successful in your study program. If you think that reason is unreasonable or that decision is unreasonable, you're able to challenge this in court and make arguments in court and try to convince a judge that, they made an unreasonable decision. And if a judge agrees with you, or if, the other lawyer on the other end says, hey, you know what, this person has a pretty good case here of this decision being unreasonable, that decision can be set aside and it can be redecided by a different officer. So I guess in a way it can be like an insurance policy, but basically it is like it's checks and balances to make sure that the government is making reasonable decisions and not just refusing applications for, any reason they like. It actually has to be a legitimate reason that they're refusing your application. So in a sense, it is kind of like an insurance policy.
Okay, my second question is, if unfortunately a perfectly well-documented visa application gets refused, our counselors usually advise students to reapply for their visa and simultaneously apply for a judicial review. Is that good advice?
What I'll say is, so generally JRs take some time, right? So they can be resolved in as quick as 1 month, or, if it takes all the steps that are necessary in order for a court date to be set, it could take up to a year. So it really depends. Like, we aren't able to say, hey, this is going to be done in this many months, just because there are other people at play. There's a lawyer representing IRCC, and then there's also a judge. So unfortunately, I can't read their minds. So I won't be able to tell you, what decisions they're going to make. But the timeline could be anywhere from a month to over a year. So you might not want to wait that long. Rather than doing that, you can apply for judicial review and then also reapply at the same time. Whether you want to reapply at the same time, like right away, or if you want to wait until, you get the decision notes to see, the exact specific reasons why you were refused, that's up to you. But, nowadays they are sending the officer's decision notes where they tell you exactly the reasons you are refused. So what you can do is apply for a judicial review on the application that was refused, and then also submit that new application using the officer's decision notes to make any tweaks to your application to make it, even more stronger than it was on the previous submission.
Question 3. When students apply for a judicial review, they don't need a new PAL. Is that true?
Some of the benefits you get when you apply for a judicial review rather than just reapplying is you're not going to have to submit, a brand new application, pay like the reapplication fees, get a new PAL. Like that's going to be a big thing. When you do reapply, you're going to need to get a new PAL from your school. Just given the current rules that are in place in Canada, like each PAL is only good for one application. So you're not going to need to do that. And, given the current, climate that we're in, schools might be unwilling to give you a new PAL, based off of if they have any left, based off of the fact that your previous application refused, whatever it might be. So they might not be willing to give you a new PAL. And you're not going to need to, gather all of your information again, maybe give an updated SOP, anything. The judicial review is going to be reviewing what was submitted at the time of your application. So it will save you all that, and you're not going to have to pay the government fees again for a reapplication and then wait, and then, maybe even get the exact same result that you just got on this previous refusal. And you're essentially just challenging the decision that was made on your previous refusal, and hopefully a judge or even opposing counsel agrees that it wasn't an unreasonable decision, and we're able to get that decision set aside and it gets redetermined by a new officer.
Okay, so now just to summarize, a judicial review is not a second chance to submit new evidence or have a visa application reassessed, but it is a review of the fairness and legality of the original decision-making process, right? So Karunvir, what is your message to Canam students, and are there any special discounts for them? They do need a resolution to this great visa refusal, however.
So basically, to conclude, a judicial review it's not a second chance to submit new evidence for the application you made. What my job is when I'm doing a judicial review is I'm taking a look at the officer's refusal notes, so the exact reasons why they refused your application, and then I'm taking everything that was submitted for your application and making arguments on why the refusal was unreasonable. And so that's basically what a judicial review is. So what I can tell you is our regular price for a judicial review is about $900. But due to our partnership with Canam, that's actually only $350, so it's significantly less compared to industry averages. So going to any other lawyer in Canada, they're probably going to charge you between $5,000 to $10,000. And the reason for this is one, judicial reviews generally take a lot of time, because you have to review all this evidence that was submitted, and then you have to draft arguments, and there's several steps back and forth. The reason we are able to do this at such a heavily discounted rate is we have come up with the technology and processes that really speeds a lot of that up. Also, I've just done so many now that I just kind of know what exactly to look for when I see specific refusal reasons. I know exactly where to go in an evidence package and what documents to look for. So basically that is what you'll be getting.
And to you students, please seek legal advice. It's highly recommended to hire a lawyer with expertise in judicial review. And Team Canam can help. Follow us on all our socials, subscribe to our YouTube channel, and comment below to get responses. And see you soon.